Good morning, everyone. The 14B District Court is now in session. My name is Irene Washington, and I'm the judge that will be presiding over this session. Please remain muted until your case is called. Once the case is called, please wait until the attorneys place their appearances on the record. They will state their name and who they represent. And then after that, make sure that your screen is on. Make sure your screen is on and that you are unmuted, and then state your name and we will proceed with the case. The court will call the case of the state of Michigan versus Tanisha Goodgame, case number 25S00189.
Tiffany Woods for the people.
Good morning, Judge Cowgirl. On behalf of Miss Goodgame. Miss Goodgame, please state your name for the record.
Tanisha Goodgame.
Thank you.
So, Your Honor, thank you. So at this time, we did receive an offer yesterday. Defense would like a little more time to consider this offer and discuss our options. So we would just ask for one more brief final adjournment.
Does August 14th work?
Let me double check, Judge. I think so. If I can just have a moment to bring up my calendar and that date. Judge, August 14th works.
August 14th, 2025 at 9:00 a.m. Bond will continue.
Thank you, Judge.
Thank you. Have a good day, everybody.
You as well, Judge. Miss Goodgame, you can look.
Court will call the case of the state of Michigan versus Shirley Jones, case number 25S00244.
Tiffany Woods for the people.
And good morning, Your Honor. Robert Elman with and on behalf of Miss Jones. Miss Jones, can you please state your name for the record?
Shirley Jones.
Thank you. Good morning, Ms. Shirley Jones. We're here for today.
Yes, Your Honor. I've been in touch with Miss Woods. We've been communicating, but I think we need a little more time to reach a potential resolution of this matter. I'd be asking for an adjournment at this time.
Either August 14th or August 28th.
I will take the 28th, Your Honor. Thank you.
The trial is adjourned to August 28th, 2025 at 9:00 a.m. There's nothing further. The bond will continue.
Thank you, Your Honor. Have a great day.
Thank you. Have a good day.
The court will call the case of the state of Michigan versus Jacob James, case number 25S00116.
Tiffany Woods for the people.
Allison Muller here on behalf of Jacob James. Mr. James, can you state your name, please?
Unmute. Hello, my name is Jacob James.
Thank you. Good morning.
Good morning, Your Honor.
All right, we're here for a bond violation as well as a pretrial today.
Yes, Your Honor. We are prepared and able to address both. Should we start with the pretrial?
Let's start with the bond violation. The defendant was arraigned on June 25th, 2025 by the magistrate for the bond violations. It appears that there were positive cocaine and buprenorphine and THC on April 30th, May 9th, May 16th, May 28th, missed samples June 5th, June 12th, June 20th. Do we have the buprenorphine June 30th, July 9th, and then missed test July 18th. And I believe that there was some discussion about him being in outpatient treatment.
Yes, Your Honor.
Go ahead, Mr. James.
So you're not yet. You're
Sorry,
entitled,
I'm sorry, Your Honor.
You're entitled to have a hearing as to the allegations in this matter, at which time, if it is found that you did in fact violate your bond conditions, your bond could be revoked. Do you understand those parts?
Yes, Your Honor.
Right. Now, Ms. Muller, you wanted him to, did you guys talk about what you're doing with respect to this bond violation?
We did, Your Honor. Mr. James, you went over the bond violation, I believe, with Mr. Works, correct? You do understand what the violations are, and I understand you will be admitting to the bond violations, correct?
Yes, Your Honor. Yes.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Lower your hand. Is it true that you tested positive in the times that I just indicated and that you missed those other testing times?
Yes, Your Honor. Now that this last one, I was out of town working, but yeah. And you mentioned that I tested positive for buprenorphine in July, but I have a Suboxone doctor, so I don't know if those are violations. But my first time on bond, yes, I was testing positive, but then I seek treatment. And since I've seek treatment, all my tests have been negative.
All right, thank you, sir. All right, I find that there's a knowing, willing admission to the violation. Are you satisfied, Ms. Woods?
Yes, Judge.
Defense is also satisfied, Your Honor.
All right, as to the pretrial.
Yes, Your Honor, there is an offer from Ms. Woods that we'd like to move forward with today. And Your Honor, the offer would be to plead to 2 reduced counts for each charge. So Mr. James will be pleading to operating while visibly intoxicated instead of the operating while intoxicated.
1 second. So he's going to be pleading to an added count 3 of OWVI
Correct.
and an added count 4
Of driving with the suspended license first offense, reduced from the second offense.
and counts 1 and 2 will be dismissed. Is that a correct statement of their agreement, Ms. Woods?
Yes, Judge, that is correct.
Thank you. I'm just writing everything up. All right, sir. Operating while visibly impaired is a misdemeanor. It carries a maximum penalty of 93 days and or a $300 fine plus court costs. And driving while license suspended is also a misdemeanor, and it carries a maximum penalty of 93 days in the Washington County Jail and a fine of up to $500 plus court costs. Do you understand the maximum potential penalty, sir?
Yes, Your Honor.
And it's the prosecutor's offer that if you plead to both of those, then the original counts, the more serious ones, would be dismissed, both counts 1 and 2. Is that what you want to do?
Yes, Your Honor.
You've already been sworn in, so I don't need to swear you in again. So I'm gonna go over the rights that you have with respect to these charges, okay? You have
Yes,
the
Your
right, you have the right to have a trial, either by a judge or a jury, as to the original counts. And you could call witnesses to speak for you. You can get an order signed by this court to require that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you. And you have the right to be a witness for yourself, or you could choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes, Your Honor.
You understand that by entering into these pleas, you're going to be giving up all of those rights, and you're not going to be having a trial of any sort.
Yes, Your Honor.
You also understand that there's no automatic right to appeal this decision. So the decision you're making today, in all likelihood, is going to stick with you.
Yes, Your Honor.
And if you were on probation, parole, or bond when this happened, and that was on January 19th of 2025. If you were on probation, parole, or bond, and you're still on it, you could
All
be
right,
in violation.
let's talk about that. The hearing for Jacob James had a little bit of everything: bond violations, positive tests, a treatment journey, and even a plea deal bundled into one session. Presiding over it all was Judge Irene Washington, whose approach was clear, steady, and no nonsense. Right out of the gate, the court tackled the bond violation allegations, a series of missed tests and positive results, stretching from April to July, with everything from THC to buprenorphine flagged. Now, if that list sounds long, well, it was, but what stood out wasn't just the technical violations, it was how James took ownership of them. He admitted to the positives, acknowledged the missed appointments, and explained that once he sought treatment, the results began to change. He even clarified that his current Suboxone use was part of a medically supervised plan, which is the kind of detail that matters a lot in this setting. Judge Washington handled it all with composure, offering James the opportunity to respond without jumping to judgment. After his explanation and a sworn admission, the court found his statements credible and moved on to the pretrial side of things. That's where things took a turn for the more hopeful. Prosecutor Tiffany Woods had a plea deal on deck. Reduced the more serious original charges down to operating while visibly impaired and for stiffens driving with a suspended license. That deal wiped out the second offense and more serious charges, which is a significant shift in a defendant's legal trajectory. James accepted the offer without hesitation, and defense attorney Allison Miller confirmed the plea agreement on the record. The court made sure James understood the rights he was giving up: trial by jury, the ability to confront witnesses, and the presumption of innocence. Sandy agreed without missing a beat. What really landed in this hearing was the sense that the system, while strict, was still working with James, not against him. It wasn't a free pass. Judge Washington reminded him that these decisions carry long-term consequences, but it was a sign that accountability and opportunity can still walk hand in hand in the right courtroom. James came in with a long list of setbacks, but also with signs of progress, treatment underway, a legal team advocating for him, and a willingness to own the past without making excuses. Sometimes a courtroom isn't about drama, it's about quiet progress. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.